Hello. Thank you for viewing this pre-recorded virtual education session, Protecting Abortion Access in Arizona. I'd like to introduce our speakers for this session to you. Hayleigh Crawford is a Deputy Solicitor General and Chief Counsel of the Special Litigation Section in the Arizona Attorney General's Office, as well as the Director of the office's inaugural Reproductive Rights Unit. Before joining the Attorney General's office, Hayleigh was a partner at Osborne Maladon, where her practice focused on civil appeals and complex civil litigation in both state and federal court. A former law clerk on the Ninth Circuit Court of Appeals, she is also active in the State Bar's Appellate Practice Section, of which she served as the chair of the Executive Committee. Next, I will introduce Dr. DeShawn Taylor, a gynecologist, family planning specialist, and gender-affirming care provider, also reproductive justice activist, whose work advances reproductive health care access through direct services, education and training, advocacy, and leadership. Dr. Taylor is the founder and CEO of Desert Star Institute for Family Planning, a nonprofit reproductive justice organization committed to creating equitable access to reproductive and sexual health care while centering Black and Indigenous people of color. Dr. Taylor is also an author. Her book, Undue Burden, A Black Woman Physician on Being Christian and Pro-Abortion in the Reproductive Justice Movement, provides a new prism from which to address the attack on abortion rights in America. Thanks again for joining us, and we hope that you find this session engaging and informative.
Just start off giving you a little bit of some background about Desert Star Institute for Family Planning, which is the organization that is hosting today's educational session. We are a 501c3 tax-exempt organization operating in Phoenix, Arizona since 2017. And our mission is to create equitable access to sexual and reproductive health care while centering Black and Indigenous people of color. And we have 4 scopes of work. One is training the next generation of abortion providers using the reproductive justice framework, which helps people understand the holistic approach and all the intersecting issues that a person is bringing in with them to the clinic. We're not just emptying uteruses. We're taking care of whole people who have whole lives. And so we train from that viewpoint. So not only do our trainees get technical skills, but they also get an understanding of how to take care of the whole person. And we're also cultivating reproductive rights and justice advocates. Many of our former trainees have written op-eds and done some really great advocating when they go back to the communities that they serve. So people come from across the country to train with us in Phoenix, and then they take those skills back to their regions of the country. The other scope of work is our patient assistance program for family planning. So we provide the Liletta intrauterine device, which is the hormone-releasing IUD, and the Nexplanon birth control implant, and then also some assistance for people who are seeking abortion care at Desert Star Clinic. We provide those through your generous donations and through partnership with Medicines 360 that makes the Liletta. They actually provide that device for free, but we otherwise cover the entire cost of the office visit, the insertion. And for the Nexplanons, we actually have to buy those. There's no program for us to get those for free. So your generous contributions help us provide those programs to people without any cost sharing. And then the patient assistance programs, there are a lot of different abortion funds available. Well, not a lot, but there are several abortion funds available to people. And so our funds kind of fill in the gap where people may fall short and otherwise still need assistance plan for their abortion. And so the next scope of work is our community education and engagement. So that's what this event falls under. where our goal is to have inform people on very important issues related to the reproductive health, rights, and justice. And so having Hayleigh with us from the AG's office is our first virtual education event of the year. We will be providing these educational sessions every other month. And then we recently acquired Desert Star Family Planning Clinic, which used to be my privately owned clinic for the past decade. And so that rounds out our fourth scope of work, which now Desert Star Institute for Family Planning is a direct service provider, fulfilling our mission through providing direct abortion services and gender-affirming hormone therapy for adults, as well as all of our programs previously ran through the clinic. And so everything is all combined in one entity now. So we are the newest nonprofit abortion clinic in Arizona. We just received our license earlier this month. So without further ado, I want to turn our attention to why we are here tonight. And our Attorney General's office has been working tirelessly to protect our access to abortion here in Arizona. We are very, very fortunate. Our Attorney General barely won that election. And for me, I hold that up as an example of how our vote really does matter and how important it is to be civically engaged and show up at the ballot box. Because I have no misunderstanding that abortion would be illegal right now in Arizona completely, based on the trajectory that we were on before our Attorney General won that election. And so without further ado, I'm going to pass it on to Hayleigh, who during the course of her introductions will also let you know a little bit more about herself. Hayleigh, let me get your slides ready, sorry.
Great, thank you, Dr. Taylor. I am thrilled to be here tonight, and thank you again for the invitation. The Attorney General's office, as you mentioned, has developed a reproductive rights unit. It is our inaugural reproductive rights unit here in the state of Arizona, and we're very excited to be able to engage with the community and do some educational outreach, because I think that is a hugely important aspect of the work that we do. My name is Hayleigh Crawford. I joined the Attorney General's office just about a year ago now. I came over from private practice after Attorney General Mays was elected. I came with another one of my partners to the Solicitor General's office. And shortly after I was hired, Attorney General Mays formed the Reproductive Rights Unit. There are similar units and task forces in other state attorney general's offices across the country. We had not had one until Attorney General Mays was elected. So she formed that shortly after she was in office and asked me to be the director of it. I have some relevant legal experience in this area. When I was in private practice, I did a lot of work representing the state and local governments. So I did a lot of sort of constitutional litigation, which dovetails with a lot of the work we do in the Reproductive Rights Unit. And on a personal level, I was raised in Mississippi, so I have seen firsthand the effects of not having adequate access to care or even education about what your options are. So it is something that I personally feel strongly about. But at the end of the day, I am a lawyer, so I do have to start this with a disclaimer, which is that this program is informational only. It does not constitute legal advice. It is not legal advice from the Attorney General's office, and we cannot represent any private constituents. So if you have particular questions about how the law might apply to you or actions that you can take legally, then we encourage you to consult private counsel or reach out to one of the organizations that you may be familiar with who may be able to assist you in navigating some of these laws. If you have general questions about the Attorney General's office or what we do, I've also included the general email address and the contact page for the Attorney General's office in these PowerPoint slides as well. And Dr. Taylor, will these be posted somewhere for people to access?
So we are going to have the video on the YouTube channel.
Right.
So it'll be part of that, but we can also, if you would like, provide the slides in the follow-up.
That would be great. And I dropped my email address in that chat there. So if anyone has follow-up questions or would like a copy of the slides, please feel free to reach out to me as well so you can access those resources. So to begin with, I just want to introduce the unit and the work that we do. Next slide, please. So as I mentioned, we were formed about a year ago by Attorney General Mays. The idea of the Reproductive Rights Unit is to have a cross-divisional task force of attorneys within the Attorney General's office so that we can draw on the expertise and knowledge of our attorneys in a variety of different divisions and sections. Because as you know, reproductive health care is not a single issue problem. It spans a lot of different areas. So to that end, we formed the Reproductive Rights Unit, which is comprised of attorneys in civil rights, consumer protection, the criminal division, licensing and enforcement, and special litigation. Now, special litigation is the section of the Attorney General's office that I, in particular, am in charge of. I know that special litigation doesn't have much meaning on its own. So what that really means is we are the section that is involved when we're dealing with higher profile constitutional defense issues, cases that are going up to the Arizona Court of Appeals, the Arizona Supreme Court, or the federal appellate courts or the US Supreme Court. So that's really what the attorneys in my section focus on. As I mentioned, I am the current director and our deputy director is Lucy Davis, and I have the names of our members there as well. We're currently about 12 members, and we find that that number has been working for us. What we do. So the Attorney General is the chief legal officer of the state. And one of the jobs of the Attorney General's office is to appear in court and defend and prosecute state laws. So we have a narrower scope than perhaps some people might understand. We don't legislate, right? And we don't advocate, and we don't lobby. What we do is we interpret and we apply and we enforce the laws. So that really means like our efforts fall into 4 buckets. Number 1 and most obvious is litigation. So we are appearing in court, either defending laws or pursuing the prosecution of laws that have been enacted by our legislature. We also conduct investigations. That very often falls under our civil rights, criminal, and consumer protection sections. So if there are alleged violations of various state laws, we can accept those complaints and conduct an investigation to find out what's going on and then take further legal action if necessary. We're also involved to some extent in regulation. Our state government division advises a variety of state agencies and boards, some of them healthcare related, for example, the Department of Health Services. So we are involved in the regulatory piece in that way. And then 4th, and perhaps most importantly in some ways, we're focused on education. Before the creation of the Reproductive Rights Unit, there really was a dearth of information coming directly from the Attorney General's office about what the state of the laws are. So that's something we're really trying to focus on fixing and becoming a resource for everyday citizens to say, what does the law say, to try and make it a little bit less confusing. On this slide, I've included some resources that the unit has been working on. I think the thing we're probably most proud of is we recently launched a comprehensive website in December of last year. The website link is right there. It includes a wealth of information, including an overview of Arizona's current abortion laws, a summary of our ongoing litigation, and that also includes an option to sign up for updates if we push out press releases or updates on currently pending lawsuits, if you'd like to be kept in the know. We also post consumer alerts there. There's currently a very helpful consumer alert about protecting your data privacy when seeking reproductive health care. And there will be forthcoming consumer alerts relating to crisis pregnancy centers. And there's also a very handy frequently asked questions page where some of the basic questions that come up that a lot of you probably get a lot of the time can be readily answered directly on the Attorney General's website. We also have links to various complaint submission portals. Now, this is really helpful because using these portals means that your complaint will be routed to the right investigators, the right people to take a look at them. So we have civil rights, consumer protection. I've also linked to the Arizona Department of Health Services where you can look up, you can both submit complaints and look up licensing status of various facilities. And then we also have criminal complaints if you believe that you've been the victim of a crime or someone else has. Now, you'll have to forgive me, I wrote anonymous next to consumer protection. What I actually meant there was confidential. So by law, consumer complaints are confidential when submitted. These other types of complaints are not technically confidential. Although we don't go around disclosing all of your information, we are subject to public records laws. So if you're submitting these other kinds of complaints, they could eventually be subject to disclosure, but we take all the steps possible to protect your information to the extent we can. But that is something I want to make people aware of.
Thanks, Hayleigh. This is such good information. Does anyone have any questions about the Attorney General's office, Hayleigh's role there, the Reproductive Rights Unit? We've also provided those links that were in the slides on the chat for you as well, so that you can have those for yourself. I was very impressed by the reproductive rights section on the site. I feel that it's comprehensive, it's easy to navigate, and I was very happy to see it because, as you mentioned, we didn't have that information. And I personally was receiving a lot of questions from people about where do we find information about what our rights are related to abortion in Arizona. So thank you and the Attorney General's office for that.
Of course. Sorry, I would
Oh,
encourage people too, if they have suggestions about areas that they would like to see us cover or potential consumer alerts, I would really encourage people to reach out to us with those ideas, because we are looking to engage with the community and really hear from you all about the issues that you're seeing on the ground and how we can best address that.
So we do have a question in the chat. Have you had any cases that we can learn from thus far? We will have a section on pending litigation. Mary Ellen, are you referring to that, or are you talking about some of these consumer things that Hayleigh provided information about? Anything. So okay. Yeah, we'll have some time for Q&A at the end. So we'll see what comes up as Hayleigh goes through her other sections of information. Lee Spencer is asking, where's the clinic located? So we are on 19th Avenue in Missouri. The address is 5501 North 19th Avenue, and we are in Suite 420. All right, so having no further questions, we're going to get back to it.
All right. So next I want to turn to where we are, the current state of Arizona's abortion laws. And it would seem like this should be a fairly straightforward issue, right? You read the law and read what it says. Unfortunately, that's not the case. So we're going to try and offer a little bit of clarity here. We're going to go over 3 different aspects. This is not comprehensive, but I am covering what I believe the biggest pieces are that you really need to know. That includes federal abortion law, Arizona abortion law, and an executive order that Governor Hobbs issued last June pertaining to reproductive health care in the state. So we're going to start with federal law. As an overview, it's important to understand a little bit of how our legal system works to understand how the laws are currently operating. The United States Constitution is the supreme law of the land, and so that is going to be determinative. If there is a right that is permitted by the federal Constitution, then it cannot be outlawed in a state constitution or by state laws or by legislation adopted by either the federal or state legislature. So we always start with the constitutions. At the state level, we also have a state constitution. That's going to be the supreme law of the state. So similarly, the Arizona legislature can't adopt laws that conflict with our state constitution. But then you also have legislature adopted laws, typically referred to as statutes, which will provide additional rules beyond what is stated in the Constitution. And then you also have case law, which is often called common law, where courts will interpret constitutions and statutes, and that develops another sort of third body of law called the common law. So that's kind of our overarching framework that we're working in, and that's why we're starting with federal law. Now, as probably most everyone on this call knows, from 1973 to 2022, there was a federally recognized constitutional right to abortion under the U.S. Constitution. In Roe versus Wade, the United States Supreme Court determined that the U.S. Constitution provided a fundamental right to abortion, and thus that was the source of the protection for this right. There had been no federal legislation adopted codifying that right, so it was really just based on the US Constitution alone. Then on June 24th, 2022, the United States Supreme Court issued Dobbs versus Jackson's Whole Women's Health Organization, which overturned Roe versus Wade and said there is no constitutional protection or constitutional right to abortion provided by the United States Constitution. In effect, what that decision did is say, we're not saying that the federal Constitution protects anything, we're returning this question to the states. So the key takeaway is that we have no recognized right to an abortion under the US Constitution. There is no federal legislation protecting the right to abortion, which means we have to look to state law to determine what your abortion access rights are. Here in Arizona, we have a constitution that includes what's called a privacy clause. It is actually a little bit more definitive than the US Constitution. The US Constitution doesn't actually mention the word privacy, and Arizona's Constitution does. But no court in Arizona has definitively decided whether Arizona's privacy clause independently provides a right to have an abortion. That issue has not been decided. So because it hasn't been decided, we effectively have no Arizona constitutional right to abortion that has been recognized by a court at this time. Our state statutes do allow for abortions in limited circumstances, however. And I want to be clear, when we're talking about abortion under Arizona law, there is a statutory definition for abortion, which is included here on the slide, which is defined as the use of any means to terminate the clinically diagnosable pregnancy of a woman with knowledge that the termination by those means will cause, with reasonable likelihood, the death of the unborn child. So that does not include things like abortion under Arizona law, does not include things like birth control devices like IUDs, oral contraceptives that inhibit or prevent ovulation like hormonal birth control pills. It does not prohibit oral contraceptives that prevent or inhibit conception or implantation, such as Plan B or the morning after pills. And most importantly, and this is an area where I see a lot of confusion, it also does not cover means used to terminate an ectopic pregnancy or to remove a deceased fetus. So if you have a miscarriage and your doctor performs a surgical procedure to remove the deceased fetus, that is not an abortion under the definition in Arizona law.
I was trying to unmute myself, actually. So there was a question in the chat, Hayleigh, about why diagnosable and not diagnosed.
That is a good question. That hasn't actually been litigated. It hasn't come up. That hasn't really been an issue in terms of how we're defining it. My best guess would be that's probably a definition that they took from some model legislation that was given to them. But as far as I'm aware, that distinction has not had any practical legal effect in terms of legal disputes that are going on.
I would agree. Okay.
So this slide is the biggie in terms of Arizona laws. This is what you've probably heard about in the news. These are laws that are currently on the books in Arizona. And you'll see at the bottom there, I have a little yellow star. As we go through the next couple of slides discussing these Arizona laws, I've tried to indicate the ones that are currently subject to litigation. And what that really means is whether those laws are in effect and how they're applied could change over the course of that litigation. So what we're talking about now today is what the law is today. And we're indicating that those things could change even in the short term. So the two major laws on the books here in Arizona, the first one is a territorial era ban. So this was a law that was originally enacted in 1864 before Arizona was even a state, and then subsequently codified by a later legislature in ARS 133603. This is a law that was pretty common pre-Roe, is my understanding. It's a general prohibition on anyone from performing an abortion except when the abortion is necessary to save the life of a patient. After Roe v. Wade was overturned, the prior Attorney General actually sought to have this law reinstated over the newer law, which I'll discuss in a minute. So that's why that's at play right now. It had been enjoined after Roe v. Wade passed, and enjoined means that a court said this law is on hold and cannot be given effect. So that law had been on hold while Roe v. Wade was in effect, and then once Roe v. Wade was overturned, former Attorney General Brnovich had said, hey, I think this law should take precedence. Now, while that law was on hold, the legislature in 2022, it also enacted a 15-week law. And that's in ARS section 362322. This law permits abortions before 15 weeks of gestational age, and also at any time in cases of statutorily defined medical emergency. This is currently in effect. So the issue we had once Roe v. Wade was overturned is we have these two laws on the books. The former Attorney General said, hey, I think these two conflict with each other, and we should give the territorial era ban control. It should control over the 15-week law. When Attorney General Mays was elected, she disagreed with the prior position taken by Attorney General Brnovich and said, no, I don't believe that's correct. What we should be doing is construing both of these laws, which are both technically on the books, to give effect to both of them. The Arizona Court of Appeals agreed with Attorney General Mays on that and with our office on that point. It has since been appealed to the Arizona Supreme Court. The Arizona Supreme Court heard an oral argument in this case in December of last year, and a decision could come down anytime. Now, I think the two key things to understand with respect to this 15-week law is that it still has no exception for rape or incest. The only exception for abortions after 15 weeks gestational age is that statutorily defined medical emergency. And I've included the key points of that medical emergency definition here. It's a situation where an immediate abortion is necessary to avoid the patient's death, or when delaying an abortion will create a serious risk of substantial and irreversible impairment of a major bodily function. Now, a lot of these terms aren't further defined, like what it means, substantial and irreversible impairment. So those sort of contours are unclear what that's going to mean in practice. One of the things I found interesting is during the oral argument before the Arizona Supreme Court on this issue, the plaintiffs who had sought to reinstate this law, or the petitioners, their counsel actually argued that this immediate abortion qualifier and medical emergency exception would mean if a woman were diagnosed with breast cancer and needed to receive chemotherapy treatment, in their opinion, that would not be a medical emergency because you could delay chemotherapy if necessary, get that treatment after the baby was delivered. So they took a pretty narrow view of what would constitute something that was necessary to save the life of the patient, which was something that my ears perked up when I heard that. And as I said, that is an issue that is still to be sort of worked out in practice, what exactly it means, but this is the statutory definition that we have. And I know those are really big topics, so please, if anyone has questions about those, I'm happy to answer them now.
See, I did see something come through the chat. This was still on the diagnosable versus diagnosed. So in other words, there does not need to be a clinical diagnosis if a woman takes mifepristone at home after a home pregnancy test. Is that a clinical diagnosis?
So that has not been litigated to my knowledge. My expectation would be that if there were a prosecutor looking to prosecute someone under these laws, assuming that this was after our 15-week situation, and somebody was providing mifepristone for the basis of terminating a pregnancy, I'm assuming that a doctor would require some sort of evidence of a pregnancy, right, Dr. Taylor? So I'm not sure how that would work out in practice. Actually, I'm not sure that issue would come up because there are limits on when you can prescribe medication abortion that would not conflict with that 15-week. So it may not be an issue, but perhaps Dr. Taylor can speak to how that process actually works in practice if you're prescribing.
Yeah, so the issue here is The portion of that 1864 law that people are concerned about that potentially could criminalize someone for the pregnant person for their abortion. And so that was actually repealed. That portion of the 1864 law was repealed. So the issues around whether someone is self-medicating an abortion, there's not really any legislation to enforce related to criminalizing that person. The issue, though, is people's having mifepristone and how they got it, because we do have some laws around that. So as we're seeing across the country, you know, folks would end up being criminalized for other ways that they are accessing, disposing of remains and those type of things, not necessarily the act of self-managing the abortion.
Yeah, I would agree with that. You know, the focus has really been on sort of shifting some of the attention away from the patient itself and shifting it to doctors or to other people who provide assistance in accessing this care, even, you know, acquaintances or relatives, as you've seen in other states.
There are some questions getting into access to mifepristone and mailing, and so Hayleigh will be speaking to that a little bit as we go forward. So we'll put a pin in that. And then I also see something in the chat that seems to be in reference to crisis pregnancy. Well, we are now calling them anti-abortion centers, call them by their fruits. So we'll put a pin in that one too. Okay.
So again, to recap here, the territorial era ban has been partially enjoined right now by the Court of Appeals, while the Arizona Supreme Court is deciding how to resolve the conflict between these two laws. So as it stands today, doctors are allowed to perform abortions consistent with that 15-week law that we have described here, which allows up to 15 weeks and at any time in case of medical emergency. We also have a number of other laws. Again, this is not comprehensive, but I tried to call out some of the really big ones that have sort of been the topic of conversation recently. One of those is the telemedicine ban that is in effect, and it is not subject to litigation. So that is a currently effective ban here in Arizona, which provides that a healthcare provider shall not use telehealth to provide an abortion. So my understanding is this is really geared towards providers who are seeing patients via telehealth and prescribing abortion medication. But again, I'm not aware of this having been litigated yet in Arizona, so the exact contours have not been defined. The second is the reason ban, and this is subject to litigation. It is currently in effect as it stands right now today, but it is still subject to a legal challenge. So the reason ban prohibits doctors from performing an abortion knowing that the abortion is sought solely because of a genetic abnormality, race, or sex. There was a lawsuit filed by a pro-choice group challenging this genetic abnormality prohibition as unconstitutionally vague and in violation of the U.S. Constitution before Roe was overturned. Now that Roe has been overturned, it's a narrower challenge challenging the vagueness of this genetic abnormality reason ban. So there's been a lot of back and forth. The trial court put it on hold. They took it off hold. It went up to the Ninth Circuit Court of Appeals. As it stands today, we'll talk about this a little bit more. However, that law is in effect. The next one is the fetal personhood policy. This had been kind of off the radar because it is currently enjoined in Arizona. The same act, the same legislative act that adopted the reason ban I just described also included the addition of a new statute in Arizona, Section 1-219, which directs that Arizona laws must be construed to acknowledge that an unborn child at every stage of development has the same rights, privileges, and immunities available to other persons. Now, this has some echoes of what's happened in Alabama, but this is actually statutory. That was enjoined by the same court that's considering the reason ban But as I mentioned, it is still the subject of litigation, so that has not been finally resolved, but is not in effect today. I list some other requirements that are still in effect. Many of you are probably familiar with most, if not all of these, such as mandatory ultrasound, counseling, a waiting period. There's also parental consent requirements for minors. There is a judicial bypass process that minors can access, but you have to have one or the other for a minor to access abortion care. And there's also a number of requirements placed on facilities and providers, which Dr. Taylor could speak more to. But as I said, I think this is a fairly educated crowd, and you probably don't need me to delve into those here. Again, the key takeaway, though, is that abortion right now, as it stands today, is generally legal in Arizona before 15 weeks and in a medical emergency at any time. But this could change on short notice because of pending litigation. The final thing I'd like to talk about in terms of our current state of the law is an executive order that Governor Hobbs issued last June. So this executive order 2023-11 addressed reproductive health care. And among other things, it stated that the Attorney General shall be responsible for overseeing all criminal prosecutions arising under the abortion statutes. It also directed that state agencies should not cooperate in other states' investigations or the prosecution for alleged violations of their reproductive health care laws. And it also indicated that the governor would decline extradition requests from other states for alleged violations of their reproductive health care laws. Now, this came out at a time when you were seeing a lot more instances of states attempting to reach across state lines to prosecute people who perhaps traveled out of state for abortion care or who assisted someone else in traveling out of state for abortion care. Now, it's key to understand that this executive order it is not a law, it isn't legislation passed by our legislature. And there are some qualifications in there. For example, it says that state agencies won't cooperate with investigations to the extent permitted by law to refuse to do so, and unless ordered by a court. So, for example, if a court had ordered that one of our state agencies needed to turn over evidence to help a court in Texas pursue a prosecution, then they would still be required to do so under the order. But the other important thing to know is, as a practical matter, the governor has directed the Attorney General to assume prosecutorial duties with respect to the abortion statutes in Arizona, and Attorney General Mays has publicly stated that she will not pursue criminal prosecutions of abortion providers in Arizona.
So I knew we were getting to the question slide, so I was like, okay, let me let you get through there. So I think that, from the provider standpoint, it's important to note that at the end of the day, some of these nuanced ways that laws can be interpreted and whether they would be challenged or not or tested, it's a bit of a moot point, because at the end of the day, they may not be tested unless someone's willing to possibly lose their practice or go to jail, right? I know I didn't go to medical school to go to jail. So I think that, each of us has to decide what level of risk we're willing to take. I know that some of us, have a greater tolerance for risk than others here in Arizona. And so that creates the landscape of, when things are available and not, especially immediately after the Dobbs decision in the summer of 2022. I wanted to give some context to the telemedicine. So actually that telemedicine ban was never challenged because it was dropped into a law around the time where telemedicine abortion was not a thing. So basically there was this study out of one of the Planned Parenthoods in the Midwest about using telemedicine for abortion. And so before it had been data published and folks were like, oh, that's cool. And so before we can even consider that we would try to figure out how that would work here in Arizona, it was a law. So someone made a comment in the chat around COVID. And so what happened was, during the COVID pandemic, there was a lot of opportunity to innovate around people being able to have visits via telemedicine, have less touches in the clinic for exposure, being able to have mifepristone mailed to them. But because the way the Arizona law is written, it supersedes those federal things. So mifepristone has to be administered in person by a physician. It can't even be a nurse practitioner, a PA, a midwife, nada. They have to be physically in the clinic in the presence of the physician who hands the medication to the patient. And so that's what held that up, along with the telemedicine ban. And with our legislature, there were some attempts to legislate on this issue that never got committee hearings, which is usually the case for all of our goals to expand family planning in this state with our current mix of folks who legislate for the state. So it is imperative. We're not going to get too much into civic engagement because that's not the purview of our visitor today. But I just want to say it is so important for us to show up and exercise and make our voices heard at the ballot box, because there are so many great things that the administration is trying to do at a federal level that we can't even provide to the people of Arizona because of our laws. Let's see what else is here.
Yeah, it looks like we have 2 questions in our Q&A right here. And I think the first one is for me. The question is, are there limitations to the Attorney General's ability to take responsibility for prosecutions, i.e. can county attorneys somehow still supersede her? And the short answer to this is it hasn't come up. And under the executive order, it does say, and under the state statute that's cited in that executive order, the Attorney General can be directed to supervise the prosecutions and to provide advice to county attorneys. But as a practical matter, we are not aware of any county attorney prosecutions, and so this issue really hasn't come up. We also have a question about the current ballot initiative, and we will be talking about that a little bit later in the slides. Dr. Taylor, if you wanted to weigh in on that now, please feel free.
I'll put a pin in it for now, and then we'll come back to it and determine if the person felt it was answered well enough with the slides. And then still remembering that there's an anti-abortion center question that we're gonna want to address too. So let's go back.
I thought I saw one more question here in the chat. I'm going to jump in on that. Asks if we're benchmarking with other states. Let's see here. Are we benchmarking with other states as far as what they're doing for laws and regulations around reproductive health care? The Reproductive Rights Unit is obviously monitoring. We do participate in multi-state meetings and calls, and so we are collaborating nationally and keeping an eye on things that are developing. But again, our office is law enforcement. And we are attorneys, so we don't actually participate in legislating or direct advocacy. So that's a little bit outside of our purview. But we do keep an eye on the legislative trends and legal developments around the country, yes. All right, so where we're going. This is where I'd like to talk a little bit about the most prominent cases and the potential developments in the law here in the near future. And again, we're going to focus on sort of 3 buckets, the first being Arizona litigation, the second being federal litigation, and then both state and federal legislation. So I'll begin with Arizona law, and these are, what we've done here is call out some of the biggest cases currently going on that are dealing with challenges to Arizona laws and Arizona statutes. Again, the one probably everyone's heard about is the one that was just argued in the Arizona Supreme Court, which is Planned Parenthood Arizona versus Mays. Attorney General Mays is named because they named the current Attorney General. It was previously Attorney General Brnovich who was named. So not to read anything into that, as Attorney General Mays was the one taking the opposite position. As I noted, Attorney General Mays actually reversed course from Attorney General Brnovich's position and took the position that these two laws should be harmonized rather than having a law from the 1800s control over the more recent legislative adoption. So I've got a little summary of the issue there. Really, the question is how to harmonize the two. The status is that it has been completely briefed and argued to the Arizona Supreme Court. If you are interested in reading any of those materials, they are linked on the Attorney General's website. On the Attorney General website we gave in an earlier slide, and I believe our volunteers put that link in the chat. The Arizona Supreme Court also records its oral arguments, so you can actually go look that up on their YouTube channel. That's linked through their website. If you Google Arizona Supreme Court, you should be able to find that pretty easily. And if you are interested, I would encourage you to go do that. It's important to note that in this context for that, the issue of whether the 1800s ban or the 15-week law should control or how they should be harmonized, that will be decided by the Arizona Supreme Court, and they will have the final word. This is a pure state issue, so it's not the sort of case that will be petitioned to the United States Supreme Court. So we expect the Arizona Supreme Court's decision to be the final word there. The next really big case that's pending is Isaacson versus Mays. This one is in the federal district court in the District of Arizona. Although it's in federal court, but it is a challenge to Arizona's laws. So the issue here is whether that genetic reason ban that we mentioned on the previous slide, which prohibits doctors from knowingly performing an abortion or from performing an abortion knowing that the sole reason it is sought is because of a genetic abnormality of the fetus. And then it's also dealing with the fetal personhood policy that I mentioned that purports to give quote unquote unborn children the same rights as any other persons under Arizona law. In this lawsuit, a group of pro-choice plaintiffs and a physician, Dr. Isaacson, had sued and alleged, among other things, that these laws are so vague that they violate the US Constitution. As I previously mentioned, that fetal personhood policy was preliminarily enjoined. That means that it's not enforceable while this lawsuit is going on. The genetic reason ban, the district court had said, I'm not going to enjoin it. It is going to remain in effect. The plaintiffs appealed that up to the appellate court, which reversed and basically said, the reasons that you gave trial court were not valid reasons, so go back and do it again. So they didn't say, oh, you have to put it on pause. They said you need to reconsider. So effectively, whether that law should be put on pause during the litigation is back before the district court. But it's important to realize that both of those decisions about whether to enjoin, i.e. put on hold a law during litigation, those were what's called preliminary injunctions. So it's a decision early in the case to say, should I put this on hold while we're going through the merits and deciding once and for all whether I think this is constitutional or not, or lawful or not. So the district court has not definitively ruled on the merits of the plaintiff's challenges to these statutes here. That's still to come, and that will likely be appealed up to higher courts. So we expect the reason ban and the fetal personhood issue to be in flux for a while longer now. Also on this one, I'll point out that the district court will not be the final word. As I mentioned, there will be appeals. Its final decision can be appealed up to the Ninth Circuit, and then they can seek review, although they're not guaranteed to receive it from the US Supreme Court.
I will mention that it was the Supreme Court that allowed this to go into effect because it was previously not being enforced. And it happened that same week that we got the Dobbs decision, actually. So it flew under the radar that we could no longer do abortions for fetal genetic abnormalities, even though we were still waiting for litigation around whether the 1864 law was going to be enforced or not. So that was very sneaky.
So I had a question in the chat asking about our impression of the Arizona Supreme Court and the US Supreme Court seeming pretty unfavorable. Unfavorable, I'm assuming, towards reproductive rights. And is that the case for the Arizona Supreme Court as well? I would say I can't comment on that now. I'm always happy to chat as a private citizen with anyone who would like to, but from the perspective of the office, I do not have any comment on the current composition of the court.
I will say what I've been telling people is that, you know, it's really hard to know, but we can talk about the fact that in 1972, advocates went to the U.S., the Arizona Supreme Court, to try to throw out the 1864 law, and they lost. And then with the Supreme Court Roe v. Wade decision in 1973, advocates went back and said, hey, check out what the Supreme Court, U.S. Supreme Court said. And then that's been one of the reasons why abortion has been available in Arizona. And because of Roe v. Wade, the reason we've been able to maintain the level of abortion access people had up until this point because of Roe v. Wade. So that's what I'll put out there for you because that's factual. And the Arizona Supreme Court composition has not changed very much in terms of the type of people who are on it in the past 50 years. Of course, we want to be hopeful. But I want people to be prepared for the idea that abortion could still be illegal in Arizona and behave appropriately when there are opportunities placed before you to try to make a difference. There's a question about, do genetic abnormalities include non-viable pregnancy, or are those treated as separate conditions?
That's a great question. So under this genetic abnormality reason ban, there is a narrowly written exception for what is referred to as, let me find the exact language here. Genetic abnormality is defined in the law to exclude a lethal fetal condition, which is elsewhere defined as a fetal condition that is diagnosed before birth and that will result with a reasonable certainty in the death of the unborn child within 3 months after birth. So that's pretty narrowly defined.
There is also another law, though, where we have to give people scripted information around fetal hospice and all of those other things. And so is that these laws don't they just kind of pile on top of each other. So it's hard to know exactly what is what. Because honestly, as an abortion provider, we've been proceeding that we can't do any genetic abortion. So this is helpful.
Yeah. So as the law is written, you would have to have a diagnosis before birth that you can state with reasonable certainty that the unborn child will die within 3 months after birth. And then that would be an exception to the ban on obtaining an abortion solely for the reason of a genetic abnormality.
That's a good question. Thank you.
Yeah, great question.
Okay.
Okay. Turning to federal law. So these are cases that are litigating issues of federal law that are relevant to abortion access in Arizona. And most prominent are these mifepristone cases that we had mentioned earlier, and we talked a little bit about access to abortion medication and the telehealth issue a few minutes ago. But this is a really big issue that is now before the U.S. Supreme Court. This is the first case that the U.S. Supreme Court is going to take since it decided the Dobbs decision overturning Roe. So this is really the first time abortion has been back in front of the court. And this time it's in the context of abortion medication and whether the FDA's approval of that medication for use in an abortion protocol is valid under the law. So we have a couple of competing lawsuits. Really, there were two primary lawsuits that brought this to a head. So there was a lawsuit filed in Washington, and that was brought by the state of Washington and several other states, including Arizona, where there was an affirmative suit to try and stop the FDA from narrowing or removing access to mifepristone. So that was sort of a preemptive strike saying, don't reduce access. You cannot lawfully reduce access to it. Meanwhile, in Texas, an anti-choice group filed a lawsuit seeking to invalidate the FDA's approval of mifepristone in the first instance. So they're seeking to have a court declare that the FDA's approval was unreasonable and illegal, and there should be no approval to use this medication in a medicated abortion protocol whatsoever. In the alternative, they also brought some challenges to the FDA's subsequent loosening of the regulations of how these could be used. For example, in subsequent years, the FDA had adopted regulations saying that that mifepristone could be used up to 10 weeks of pregnancy instead of just 7 weeks, and made some other sort of loosening changes there. And the plaintiffs were also challenging that in the Texas lawsuit. So both cases were ongoing simultaneously. In the Washington case, the one that Arizona joined, the district court, which is the trial court at the federal level, preliminarily enjoined the FDA from reducing access. So basically put an order in place saying everything must stay the same with respect to the plaintiff states. It was not a nationwide ruling. So that means that mifepristone remains accessible and legal here in Arizona. That's important because while the Texas lawsuit was going on, the judge there purported to enter a nationwide order, but it couldn't override the specific order entered in Washington that said, as to these named parties, my ruling is effective. Now in Washington, that case has been stayed pending resolution of the US Supreme Court issues that I'll describe to you now. So in the Texas case, back one if you don't mind. So in the Texas case, another district court in Texas agreed with the anti-choice plaintiffs and agreed to preliminarily enjoin some of the FDA's approval of mifepristone. So that was effectively cutting off access. That was appealed very quickly on an emergency basis, understandably up to the Fifth Circuit Court of Appeals. And the Fifth Circuit affirmed in part. They said, you know, the initial approval, we're not going to say that was unlawful, but some of these later loosening of restrictions were unlawful. Then we had both sides in that case sought review from the United States Supreme Court. The plaintiffs said, hey, United States Supreme Court, please determine whether the Fifth Circuit was wrong in saying the FDA's original approval was not unlawful. So they were asking the US Supreme Court to hear and decide that the FDA never should have approved mifepristone in the first place. And then the other side of the case, those folks were asking the Supreme Court to review whether those subsequent regulations that loosened the restrictions on mifepristone and made it more accessible, for example, up to 10 weeks of pregnancy, whether those were lawful or whether the Fifth Circuit was wrong in saying that those were not properly adopted. Now, interestingly, the Supreme Court granted the petitions asking it to review the subsequent loosening regulations, but it declined to review whether the FDA's initial approval of mifepristone was illegal. So that issue is not before the court, and the Fifth Circuit had already ruled that that was legal, so it does not appear that that issue is going to be decided as a part of this case. But they will be deciding whether those subsequent regulations, which provide further access to mifepristone, should be allowed to stand. That case has actually been set for oral argument, and it will be argued on March 26th. And the US Supreme Court does not televise their oral arguments, but you can listen to them via live stream if you're interested in doing that. The link to it can be found on their webpage. I think we may have, before we move on, I want to double check our questions here. Well, it looks like our question pertained to the earlier genetic reason ban issue and lethal fetal conditions. You're correct. The question was, assuming that the law does not specify whether the child would die with or without life-saving interventions. It does not specify. As it's written, I would say, you know, the will die with reasonable certainty within 3 months would contemplate that if you could save the life of the child or extend it beyond 3 months, that is likely going to take it outside of that exception.
And I'll share from a practical standpoint, you'd have to have a provider that would test that too, and be willing to go to jail or whatever other penalty comes along with it. What's been happening recently is these laws have also coming with very steep monetary penalties too, as well as actual prison time. Like they've really upped the ante to provide a chilling effect for I guess, civil disobedience as it relates to, what physicians would choose to do. And so it's been a very difficult time to be an abortion provider.
All right, so we've talked about the pending Arizona lawsuits, the pending federal lawsuits. So those concern our general 15-week law, whether that will continue to be in effect in Arizona, the genetic reason ban, the fetal personhood policy, and access to mifepristone. So those are 4 really big issues that are still pending in the courts right now that the Reproductive Rights Unit and attorneys at our office are actively litigating and taking positions to try and ensure that we maintain access to those things. On the legislative front, there are a couple of legislative things pending. The thing you've probably most heard about is the pending ballot initiative. I've included the serial number there. That's a serial number assigned by the Secretary of State's office. This is a proposal to amend the Arizona Constitution to establish a fundamental right to abortion. To qualify for the ballot, it needs 383,923 signatures to qualify to be placed on the 2024 ballot. And we've included a link here to the full text. At this time, it is just a proposed ballot initiative. Unfortunately, I cannot comment from the perspective of the Attorney General's office. As I mentioned, we don't advocate and we're not involved in legislation. So we don't use our resources to attempt to influence the outcome of elections, but this is a pending item that could potentially affect the legal landscape here. So I think it's important to note that it exists and there's some basic factual information you can find there. On the federal side, there's not a whole lot happening. There have been some discussions regarding codifying abortion protections in federal law by statute, but it looks like that's pretty unlikely to occur. There's also some limited federal regulations that could provide some limited protections. The one that you probably hear the most about now is called the Emergency Medical Treatment and Labor Act, EMTALA, and that is an act that requires hospital emergency departments to examine and treat individuals with an emergency medical condition. And there's some ongoing litigation right now about whether that requires emergency departments to provide emergency abortion care. But that's another aspect that could provide some coverage there, so wanted to mention it. So in summary, we have no constitutional right to abortion under the US Constitution and no right to abortion under federal statute. Really, we have to look to state law. In Arizona, there's no recognized right to abortion under the Arizona Constitution, but neither has it been ruled that it definitively does not provide any protection there either, I would like to note. There's also the proposed ballot measure underway to amend the Arizona Constitution to explicitly add a fundamental right to abortion subject to certain qualifications. By state law, that's state statute, that's legislation, there's a limited right to access abortion care up to 15 weeks gestational age and at any time in a case of a statutorily defined medical emergency. But again, that could change any day to limit to only when necessary to save the life of the patient, depending on how the Arizona Supreme Court rules. We are hopeful that they are going to agree with our interpretation, harmonizing the two and preserve the 15-week law, but that remains to be seen. If the court were to rule otherwise, that would mean abortion would be effectively banned in Arizona absent a change in Arizona law, which would mean we either need new legislation and or a constitutional amendment to change that. On the other fronts, the Arizona statute providing a fetal personhood policy is currently enjoined, but again, the litigation is ongoing and that could change. Now, I certainly don't mean to scare anyone with that. Really, as I mentioned earlier, one of the goals of the Reproductive Rights Unit is to provide clarity when we can. And again, this is the state of the law today. And we are doing our best to make sure that we're keeping people up to date, providing you with the most recent information about the positions that are being taken in litigation. So this is what I can tell you about what is on the books today and what could change in the near future. But again, we would love to hear from you all about what you're seeing on the ground and other areas where we can offer additional clarification and guidance. So there's a couple of things that I would love to encourage everyone to do. As I mentioned, the education component is really important. We're trying to get resources out there and we want to know what resources you'd like to see. There are clarifications that we can offer. For example, although we don't legislate, we don't make law, public representatives such as your legislators can request that the Attorney General provide opinions on matters of state law. So if there are areas that require clarification, you can ask your representative to reach out to us. There are other things that we can do, such as issuing guidance. The Attorney General may offer, statements about her official positions on things. So we do encourage you to just be in communication with our office about the things you're seeing, the things you would like clarity on, because that's really what we're here to help with. The other thing we're really here to help with beyond litigation and education is to investigate complaints. And so if you, and I believe there was a question, Dr. Taylor, if you want to circle back now about I forget the proper terminology now, anti-choice centers.
Anti-abortion center.
Yes.
Yeah, so there was a new clinic that a storefront called quote unquote Aid to Women Center with a pretty butterfly logo that opened up last year at 24th Street and Baseline. And they had wondered who they are and who funds them.
Gotcha. This is a great question. So one of the links that we put in the chat earlier is to the Arizona Department of Health Services. They maintain a searchable database of all licensed medical providers. So many anti-abortion centers are not licensed medical facilities and they don't actually offer medical care. And so one of the ways you can double check, it's not, a fail-safe, but if you want to see if this is a licensed medical facility that's being run by a physician and trained medical personnel, then you can look on that Arizona Department of Health website to see if they are licensed there. So that's the first place I would check. As far as what they do and who funds them, that's information that you would probably just be Googling for, but to the extent you're trying to check if they are properly licensed as a medical facility, I would go through the Department of Health Services. But this is a great point that dovetails nicely with this complaint section, because I would really strongly encourage people, if you are interacting with places that are representing themselves as providing medical services, but they're not, or if you feel you've been misled, or if you're, you spoke with someone and then they sold your data, you're getting, a bunch of ads and advertisements and outreach from people who are encouraging you not to get an abortion or not to access care. Those are the kind of things that our office really needs to know about so that we can investigate as a consumer protection issue. So please, please, please reach out directly, encourage other people who've had that experience. I understand it is I definitely understand it's a sensitive topic and people may not be inclined in that moment, but unless we have information, direct information about people who are experiencing this, our options are limited. So I would really encourage everyone to just call us. We're here to help to the extent we can if you have questions or you have concerns.
So it's 7:09, and thank you. The majority of folks stayed on with us past 7. I think that Hayleigh's slides, the summary slides were really good. And I think this final slide here is a really good call to action around helping to expose these anti-abortion centers. They outnumber actual abortion clinics here in Arizona almost 4-to-1. So it is highly likely, especially in rural areas, that someone will encounter one of these centers and be deceived. And especially now that we're operating under a 15-week ban, could be pushed beyond their ability to have an abortion in our state. So definitely, if you come across these, definitely send that information to the Attorney General's office.
And I'm going to put my email address in here one more time so everyone will have it. Please feel free to reach out to me directly if you'd rather not call a general line, or if you have questions or run into issues like that. I'm happy to speak with you.
And so there was a question and we'll have, this will be our final question. And that is, oh, and Hayleigh, click message all so that you can put your.
Yes, I will do that. Thank you.
And then, so this question around, can we speak a bit about how the current ballot initiative would affect the current legislation? Would it affect waiting periods, ultrasound requirements, reason bans, et cetera? And so I think this is a question that you potentially could answer, Hayleigh, in terms of what would it mean if it passed?
As a general matter, I would say that it probably will have an effect on some of those things. I can't speak to the specifics because to the extent there was the ballot passed, say that it qualified for the ballot and it is adopted by the voters, there would probably either be legislation that recognizes that some things are invalidated, or perhaps people would file lawsuits saying, hey, these laws are no longer valid. And then the Attorney General's office would probably be involved in those lawsuits. So I can't speak to those positions, but I think as a general principle, yes. Incorporating a fundamental right to abortion into the Arizona Constitution would impact some of the legislation we have on the books, much the way that having a recognized fundamental right to abortion under the US Constitution impacted our laws back in the day and caused some of them to be put on hold.
So that is a great end to a very, very informative discussion. Thank you so much, Hayleigh, for joining us tonight. This was just phenomenal information.